Okay, thank you all for coming. I will be very and uncharacteristically brief. It is my great pleasure to welcome you to the second script seminar of the current academic year. I won't say a lot about the speaker. I leave that to Roya, who I'm very grateful for actually organizing this talk. I'm very grateful for our speaker to come, but it was really mainly due to her taking the initiative that we have this opportunity. I understand that we are joined by around 50 people online. So behave yourself. You are not alone. And with that, I pass on to Roya. Thank you.
Okay, well, thanks everyone for joining us online and for joining us here on campus. I'm really excited about this. This is my first event in Edinburgh University, and I'm really happy to have an old colleague of mine here to actually make your first start here in the university. So Dick Wilder was kind enough to come over from Geneva. He had another seminar going on in Geneva a couple of days ago on IP and development things. So the issue of the talk is about managing IP for public health. I thought this is an interesting question to ask because traditionally intellectual property and public health are seen in a dichotomy, and they are seen on opposite sides. And I was interested in asking the question, can there be not an either or question, but can we find strategies that actually reconcile intellectual property with the public health folks, sort of like looking for managing IP under public health interest paradigm, which goes beyond the traditional idea of looking at IP mainly just from a compulsory licensing perspective or from a like IP just harms patients in developing countries to sort of like see, can IP actually be a means to build bridges? That is the question that I had. And I exchanged it with Dick Wilder, and he said, well, it would be interesting to present what the Gates Foundation is doing in this area, because the Gates Foundation in many ways sets novel tactics and strategies of approaching intellectual property that possibly could serve as a role model for other not profit-oriented or even profit-oriented corporations to look at IP with a novel eye, with a novel perspective. So just quickly to introduce Dick Wilder, he has quite a big CV. He is currently with the Gates Foundation as Associate General Counsel in Global Health. Before that, he worked for Microsoft for a long time in the Public Health and IP department. Prior to Microsoft, he worked for nearly a decade as a partner in a US IP law firm. And before that, he worked as a director in the World Intellectual Property Organization in the Global IP Issues Division, and had some exposure also to the US Patent and Trademark Office, moving a bit back and forth, I think, between the two organizations. So with that introduction, I'm super happy to have Dick here and to share the views, not only online, but also with the people on campus. If we rephrase your questions after the talk, that's that the people online can hear what you said. Otherwise, it should be just a normal presentation. Great. Thanks for being here.
Thank you. And tell me, Roy, if this system isn't working properly. But thank you very much for that gracious introduction. I really appreciate it. And thank you for the opportunity to be here at the University of Edinburgh. For the people online, we're in a very old, like an amphitheater type of an arrangement, where I'm in the front of the lecture hall, and a number of people are gathered here in the hall and having a discussion about intellectual property and global health. What I thought I would do is start my presentation, and actually let me just make sure I understand how the technology is going to work here. Great, thank you very much. I thought what I would start is with a reference to the Scottish moral philosopher and economist Adam Smith, in part because by doing this I can also bring in some discussion from Bill Gates about his view on what he calls creative capitalism, and I think there's a connection between the two. And also I wanted to refer to Adam Smith in part to pander to the home crowd, since he's Scottish. Let me, and at the beginning, you know, for the people here, I'm going to be reading a bit because I'll be quoting from some newspaper articles, and then from some of the writings of Adam Smith and a speech from Bill Gates. In 2009, Amartya Sen, who's the Nobel Prize winner in economics, he wrote the book Development is Freedom, wrote an article in the Financial Times. And in 2009, he was trying to draw some lessons from the economic and financial crisis, which we're obviously still dealing with today. He said that the economic crisis is not so much about the end of capitalism as about the nature of capitalism and the need for change. And for inspiration, he turned to a statement by Adam Smith in his first book, The Theory of Moral Sentiments. Smith said that prudence was, of all virtues, that which is most helpful to the individual, and that humanity, justice, generosity, and public spirit are the qualities most useful to others. So Smith didn't take the pure market mechanism to be a freestanding driver of excellence, nor did he take the profit motive to be all that's needed. An economy needs other values and commitments such as mutual trust and confidence to work well. And so Amartya Sen went on to explain that despite all Smith did to explain and defend the constructive role of the market, he was deeply concerned about the incidence of poverty, illiteracy, and relative deprivation that might remain despite a well-functioning market economy. He wanted institutional diversity, motivational variety, not monolithic markets and singular dominance of the profit motive. And I think that that one phrase is worth repeating. It's something that I'll make reference back to when I get into the substance of my talk here today regarding intellectual property management at the Gates Foundation. And that is the requirement or the need for institutional diversity and motivational variety. But of course, neither Sen nor Adam Smith dismissed the profit motive. It still plays a critical role among a broad range of motivations. And Bill Gates had some thoughts about that in a prior speech to the World Economic Forum at Davos, where he is again this week. Like Sen, he was inspired by Adam Smith and said that the genius of capitalism lies in its ability to make self-interest serve the wider interest. The potential of a big financial return for innovation unleashes a broad set of talented people in pursuit of many different discoveries. This system, driven by self-interest, is responsible for the incredible innovations that have improved so many lives. But to harness this power so it benefits everyone, we need to refine the system. So he saw the refinement leading to a system with a twin mission, making profits and also improving the lives of those who didn't fully benefit from today's market forces. And he dubbed his idea creative capitalism, an approach where governments, businesses, and nonprofits work together to stretch the reach of market forces so that more people can make a profit or gain recognition doing work that eases the world's inequities. I think this is a useful approach in considering the cross-cutting development issues and the many actors that are involved in the process. It's certainly the approach that we take in the work that we do, and we take this approach under an approach that we call achieving global access, and that I'm going to be getting into in a fair amount of detail as I get into the substance of my talk here today. So the overarching philosophy of the Gates Foundation is that everyone deserves the chance to live a healthy and productive life. And in undertaking to accomplish, that overarching goal, at the foundation we have several programs that focus on these efforts. As Roya indicated, I'm in the Global Health Program, and I'll be talking about that in a little bit of detail in just a moment. Also the Global Development Program and the U.S. program. And I think for the purpose of this discussion today, the global programs, Global Health and Global Development, are the ones that are perhaps the most relevant. U.S. program is an important part of the work of the foundation, focusing primarily on education in the United States. Voila. So this next slide is an effort to provide a little bit of detail about what the content is of the programs at the foundation. And again, the central one on global health is where I'm focused, where we focus on infectious disease, neglected diseases of the developing world. And that includes, of course, the diseases that you know a great deal about in terms of HIV, AIDS, and malaria, but then also a number of lesser diseases that are no less harmful for people in the developing world. In this context, we undertake to do discovery early stage discovery work in terms of research activities, development of the products and bringing them to market, and in this same context as well, we work on vaccine development along with drugs and diagnostics. Global development, agricultural development, and water sanitation and hygiene are ones that are very relevant to the talk here today. I think it's important actually to note in terms of the scope of the work that we do at the Foundation that it involves areas of activity with respect to science and technology where a number of different actors are involved. You know, certainly we're focused on it as a nonprofit organization. We're interested in these issues for the motivation that I gave you at the outset. But there's also a number of players that are involved both on their own as well as cooperating with us in the work that we do in the academic sector, in the for-profit sector, and government labs. And you know, this is just a rather simple slide that makes exactly the same point that I was saying earlier, is that as we do the work of the Foundation, we engage with a wide range of actors, and again goes back to the point that we look for, or we work with actors that have different motivations, whether they're in the private sector where their motivation may be both charitable as well as profit, academic, NGO, and the public sector. In the work that we do, we set up global collaborations, and at this point really what I wanted to do is perhaps give you a couple of illustrations about what that means in a practical sense. One of the areas that we work in, as I mentioned, has to do with HIV, and in particular vaccines and development of HIV vaccines. And so several years ago, I think 5 or 6 years ago now, we stood up an organization called the Collaboration for AIDS Vaccine Development. Most recently, we established another collaboration called the TB Drug Accelerator. Both of these are initiatives that at the Foundation I'm very, very proud of, both in terms of the substance of the work that's being done in developing vaccines for AIDS, but also drugs for the treatment of malaria. I'm also very proud in terms of the nature of the institution and the underlying legal work that was done. These are undertakings that involve a large number of organizations. The CAVD, the Collaboration for AIDS Vaccine Development, for example, has 100 institutions around the world, entities in the private sector and in the public sector, government labs, and these are institutions that are in both the developed and the developing world. And there's this underlying agreement in connection with that work that they would work together collaboratively, they would share data, they would share information. To the extent that there are patent rights that arise in the work that they do, they agree to cross-license those rights in order to enable the research to be done. And at the core of that arrangement, those two arrangements that I described, as well as overarching the work that we do, is what we call the global access policy. I think, I'll tell you what, I'm going to skip ahead a couple of slides and address that point, and then I'll come back. What I wanted to do in the slides that I just skipped over that I'll go back to in a minute is to talk about the various sort of legal approaches or legal instruments that we have available to us to make investments. But what I wanted to do before going into that is to introduce the concept of global access. And again, in connection with the specific arrangements that we put in place, we want to be sure that this principle is fully both enabled and respected. And I'm going to read from this actually because the text of it is very important. It's something that we've actually spent a fair amount of time looking at and working on within the Foundation, where we want to be sure that the projects that we develop result in products and services and the like that are done in a manner that ensures global access is achieved. And global access has a couple of prongs to it. In the first instance, to be sure that the knowledge and information that's developed, including data, is promptly and broadly disseminated. And secondly, and I think this is the one perhaps that you might be most interested in, is to ensure that the funded developments, that is the products, services, and the like, are made available and accessible at affordable price to people most in need within developing countries. And we also address this issue in the context of the work that we do in education. So this is, in a sense, it's the real embodiment, if you will, of the overarching philosophy of the foundation. It's the real embodiment, if you will, of the creative capitalism that I referred to at the outset. And so then going back perhaps to a couple of slides, I can talk about the various legal instruments or modes of investment that we have available at the foundation, where we undertake to do the development work, to bring the products into the market, and to achieve global access. And there are basically three, and we have grants, contracts, and program-related investments. I'm going to focus on grants and program-related investments. Grants are the largest vehicle through which we make funding arrangement at the foundation. In connection with the grants that we establish, and again, these are grants, for example, in the context of the CAVD that I mentioned, or other research projects to develop drugs, vaccines, and diagnostics, and other work, of course, in the other programs at the foundation besides global health. But when we make the grant, an essential element of that or component of that is the global access commitment, as I described on the other slide. And in connection with that global access commitment, we undertake in, I should say, not all instances. There's a couple of exceptions to this general rule that I can talk about in Q&A, but the general rule is that we go further than just making sure that the global access commitment is established, but we have a discussion, a form of due diligence, if you will, with the grantee to be sure that we understand what it is that they're going to be doing in the work, that they understand what's required from us in terms of the scientific and technical work that's being done, and that they and we both understand how it is that the global access commitment is going to be achieved. And so in that sense, what it requires is for us to have a fairly detailed understanding of the nature of the technical work that's going to be done, what inventions might arise that could be subject to patent protection, what copyright-related works in connection with software, for example, might arise because of the funded activity, and that we fully understand and we have a mutual agreement as to how those intellectual property rights are going to be managed in order to achieve global access. And it's important to have that kind of clear understanding because in the case of grants, it is the grantee that retains the ownership of the intellectual property. And because of that, then the requirement for making sure that we understand how those rights are going to be managed so that global access can be achieved is extremely important. Let me turn to another form of investment, and this is something that's allowed under the U.S. tax code. It's program-related investments. There's a number of specific rules that attach to the way that those investments are made, but perhaps what I can just indicate is a couple of different legal vehicles, if you will, that those investments can be made through. One is a loan, low-interest loan. Another is the possibility of taking an equity investment in a company. And I think that latter point, the notion of possibly taking an equity investment in a company and how that relates to achieving a charitable objective, and especially through global access, is very interesting. And I think it's interesting from a philosophical point of view. It's also interesting and somewhat complicated from a legal point of view. And both philosophically and legally, what's required is that the investment that is made leads to a charitable outcome. And again, in our parlance or the way of looking at things, that global access is achieved. And so in that context, what we do is we have the same kind of a discussion that I described earlier, and we memorialize this in the documents that we established for the investment, that global access is going to be achieved and that the intellectual property that's held by the company will be managed towards that end. And as you can probably imagine, that as we have these discussions and we're looking at particular diseases or conditions and particular technologies like drugs, vaccines, and diagnostics. As we get into the details of how the intellectual property rights are going to be managed, we have very detailed discussions about the requirement for the ultimate delivery of that product to certain key markets, especially in the developing world, for certain applications with respect to the range of diseases and conditions that we focus on at the foundation. And in the case of program-related investments, often what we're looking at is making an investment in something you might consider to be a platform technology that could have application across a broad range of diseases and conditions. Like if you know something about vaccine technology, there may be an adjuvant that goes with a vaccine that means that you have less of in essence, the active ingredient that has to be required, so there's some dose sparing. And so the adjuvant maybe have application sort of immediately in some of our programs for a malaria vaccine, but we might see that it has potential application in a broad range of diseases that we focus on. So we want to ensure that technology is made available for all of those conditions, and we establish that in the agreements that we strike for the deal. This is a slide that really expands on what I just mentioned actually about program-related investments. So I'm not going to spend an awful lot of time on this. Again, to focus on a couple of things, one in the upper right-hand corner about the primary purpose always being to accomplish charitable outcomes. And the other is that we have sort of a number of, well, I shouldn't say a number, but there are different legal mechanisms, low interest loans, for example, or equity investments that we can use for this purpose. Let me move on actually to, I'm going to skip over this slide on global access because I've previously covered that, and move on to this, which is an effort to put what I've just been talking about with respect to intellectual property management in a broader, and I think perhaps well, both a broader and a necessarily broad context. And that is, when we talk about IP management in connection with the work that we do and the investments that we make, we talk about ensuring that the IP rights that arise are managed so as to achieve global access. That's one piece of the puzzle, if you will, for achieving global access. If you contemplate the global access means the delivery of the desired products or technologies into the desired markets, there's much more that has to be done in order to accomplish that goal than just the management of intellectual property. I mean, we're focusing on that here today, but there's regulatory approvals in the case of drugs and vaccines that have to be achieved. There's local infrastructure that has to be established for diagnosis and treatment. There's a need to identify what the demand is going to be for the product. There's a need to identify the funding mechanisms for the manufacture and the delivery of those products once they're developed. And so in that connection, as I've put up, there's a number of different additional legal structures or legal instruments that have to be in place in order to ensure that our global access objectives are met, in addition to managing suitably the intellectual property. This, for those of you here that are involved at all or focused on intellectual property, what the slide that I've put up now on intellectual property management, basically is stating some fairly obvious notions. And, that is that intellectual property provides leverage. You have a right to exclude other people from making, using, selling, or importing patented inventions. You have a right in respect of copyrighted works to prevent people from reproducing it. And so you can use that leverage to achieve the objectives that you want. If your objective is to generate profit, then you can use the leverage to generate that outcome. If your leverage is to, in our case, achieve a charitable objective, then you can use the IP leverage to achieve that objective. And I'm going to circle back to that in a minute, because I think this notion of IP leverage and global access is something that is key to understand. It's also important, and again, from an IP perspective, this, is that you have to, understand, what intellectual property rights might be out there that are held by third parties. This would be, other entities. It could be universities. It could be companies in the private sector that have intellectual property that you would want to have access to or have licenses to in order to be able to bring your product to market. And then just skipping to the last bullet point, and I'm going to go back to the others here in a second, is that we also build into our arrangement certain remedies in order to ensure access is achieved. In this context, there's a number of different concepts here that I have in mind. One, for example, is the possibility that if the access that we're looking for, if the ultimate delivery of the product to the markets that we've identified isn't achieved, then there would be the possibility for us or another one of our partners to pick up and use those intellectual property rights and the third-party rights that have been secured in order to move forward with the project through another mechanism, through another entity. So that's a possible remedy. There's, of course, other remedies that we can build into agreements in order to ensure that access is achieved. But going back to this notion of intellectual property management, one of the things that we, and not just the foundation, but a lot of entities that are involved in global health and global development efforts realize is that with respect to the investments that we make in technologies, they may have an application broader than just what we have in mind. So we're talking about developing drugs, vaccines, and diagnostics that have application in developing country markets, and in particular in those markets where there may not be insurance in order to pay for them. There may not be an ability to pay out of pocket. So it's not a market that's actually going to induce directly investment by the private sector in order to enjoy a commercial advantage. But it may be that the technologies that we're investing in have a broader application in markets where there is the possibility of some commercial return. And in those cases, what we want to do is to use, that broader leverage of the IP that's available to us or to our grantees to say, we will enable you, the grantee or the entity that we funded, to use this technology broadly and achieve a commercial advantage, provided that you do what we need to be done with respect to achieving our global access objectives. That is to deliver the product to the markets that we have in mind. And so when we're thinking about intellectual property in the context of the work that we do, it's really conceiving of it in that broad way and trying to understand and trying to make arrangements that will enable us to use that broad leverage to achieve perhaps the more narrower objective that we have in mind. And the other thing in this context I think that needs to be borne in mind is that we are all operating in a world where we have intellectual property systems, we have a fairly high degree of familiarity, if not sophistication, about intellectual property across the globe. We're dealing, as I said, with organizations in the private sector, government labs, and in other nonprofits and in research-based universities that have a lot of experience and familiarity dealing with intellectual property. So that as we stand up these projects that we're working on and we make these investments and we establish the grant agreements and the collaboration agreements, inevitably the question of intellectual property rights arises. So whether we are motivated by taking advantage of the IP for the purpose of the leverage, or whether it's the entities that we're working with and funding want to address intellectual property, or for other reasons, it is an issue that arises consistently in the work that we do, and it's something that we take pains to recognize and to manage appropriately. Yeah. So this is in a way, I think, drilling down on that last point that I made, or the point that I made with respect to the notion of managing IP and taking advantage of the leverage. But what it is, and it's I apologize, it's a very busy slide. There's a lot of words on it, and you know, far too much. But you know, my purpose in using this slide is twofold. One is down at the bottom. There's the key point that talks about the nature of the agreements and IP and global access commitments varies depending on the stage of development and entities involved. And the other is to say that as we look at this whole development process from early stage discovery research work into clinical trials for the development of drugs and vaccines, into qualification, the World Health Organization has a pre-qualification process that has to do with this regulatory approval process. Actually, the WHO pre-qualification, you know, has a lot to do as well with establishing a basis for procurement, especially by UN or UN-related agencies. But moving down this whole chain from early stage discovery into clinical trial, into development and delivery into the market, there's a number of different legal instruments that we use in these processes. From the early research projects, there may be research licenses that have to be worked out, especially with entities, especially with you know, third-party rights that we might need to license in to make use of that technology. There are, you know, often we deal with material transfer agreements that have to do with biological materials that are going to be analyzed in connection with the project that we're doing. And as a consequence of that analysis of that biological material, again, intellectual property could arise, and we need to be sure that that's recognized and managed in the way that I've described. And then as you move down the chain of the process, you've got clinical trial agreements, technology transfer agreements to enable manufacture of product that's used in the clinical trials, or to enable the manufacture of the product and have it brought to market. You've got at the end of the process, when we are successful and products come into the market, there will be commercial supply agreements and procurement and financing arrangements and so forth. And you know, I would say that, well, it may not be fully fair to say that with respect to all of these types of agreements, you know, intellectual property arises. Certainly true that it doesn't play a central role in all of these agreements, but in all of these types of agreements, you know, there have been instances where we've thought about or had to deal with intellectual property. You know, many of them, again, are more central, like the technology transfer agreement inherently is going to deal with intellectual property issues. But as we go through this process, and as we of development, and as we engage with different types of organizations, you know, for, again, you know, academics and companies in the for-profit sector, we necessarily have to deal with intellectual property rights, and again, always overarching the way that we approach it is the necessity to achieve the global access commitments. So I've got a few concluding remarks, and one of them, well, you know, in part really just to summarize, you know, what I've said is that, you know, our overarching objective in the type of agreements and the engagement with the type of entities that I mentioned is to achieve global access, to be sure in the end that the products that we develop are accessible and affordable to the markets that we target. We work with, you know, pretty much any kind of an institution that you would imagine, and with respect to all of these different types of institutions, we've addressed these intellectual property management and global access issues. And the last bullet point, I think, probably states something that's fairly obvious, the sense that as we establish our projects and we use the different tools to make investments that I indicated, and as we have discussions about the technology and the intellectual property arises, we need to have a clarity of purpose, motivations, objectives, and desired outcomes. And in this sense, I mean, the way that I look at it, and this would be, the last thing that I would say really before opening it up for questions, is that, the way that I look at what we do with respect to global access and IP management is to envision that we are going to be successful from a scientific and technical point of view. That is, that we have, world-class people working at the foundation. We have the great privilege of having funds in order to engage in these activities. We have the great privilege of being able to engage with the best institutions around the world to do the research that we fund. And we are very optimistic, and we have great faith in science being able to deal with some of these just enormous problems in the world. And because of that confidence, we can envision in the work that we do that we are going to be successful. We will be successful in terms of the scientific and technical work that we're undertaking to do. And what we want to do is to say, okay, we are going to be successful in bringing these products to the markets that we want to serve. We need to envision how that's actually going to happen, how it is that the work is going to be done, the research is going to be successful, the product is going to be developed, the product will go through clinical trials and into the market, and these intellectual property rights that the institutions arise and that we see that have value in many instances as leverage, that we take that into consideration as well, so that as we land success from a scientific point of view, we also land success from a global access point of view, so that we actually can achieve what we want in terms of delivering the products that we have in mind, the services that we have in mind to the populations that we aim to serve. Thank you very much. So, questions, observations? Do we have questions online? Well, please. Well, I'll talk about that actually, because it's probably of general interest. The question was, I had mentioned that there were some exceptions to sort of the general way that we undertake to do our grant making activity, and one area that we've been piloting at the foundation recently is with respect to what we call accelerated grants, and the idea there being that we will, as the title implies, we'll be able to get the grants out more quickly. And in the pilot project, there's a dollar limit for those types of grants, and we've been doing it within the Global Health Program in particular. And because of the nature of that, because the nature of it being accelerated, it means that we don't really have an opportunity to have that conversation with the potential grantee that I mentioned, where we say, okay, you're going to do this work. It looks like maybe intellectual property will arise. And if it does, we want to be sure that we understand that and you manage it in a certain way. So we come to that agreement around global access and IP management. So we don't have a chance for that conversation, that kind of due diligence. And so what we've done is we've taken a license with respect, just an automatic license in the grant agreement to say, if intellectual property arises, then we, the foundation, get a license to that. And the one interesting, at least I think it's interesting, proviso in it is that if the grantee during the performance of the grant can demonstrate, that they will otherwise be able to achieve global access to our satisfaction, then we can terminate the license. So the idea being there is that, as you know, there are many types of licenses. There are non-exclusive licenses, exclusive licenses. We have the possibility of intellectual property in one geographic jurisdiction or globally. And so if a grantee comes to us and says it would make it a lot easier for us to develop and bring this product to market if we had all of the rights, and we're willing to ensure that we will achieve your global access objective, but we want to be able to, again, use that leverage to be able in a commercially viable sector, then we'll listen to that and make a decision about whether we want to retain the right or not. But that's the one exception. But I think it kind of illustrates the point that I was making a little bit better.
The online question is, although global access is not mainly based on IP, I'm concerned that there are types of regimes that might clash with what global access aims to achieve, particularly regulation on access to genetic resources and benefit sharing like the Convention on Biodiversity. Have you faced any challenges with this regime in your strategy for IP management?
So the question was about the Convention on Biological Diversity and whether it's been a challenge. And, I shouldn't say not the convention as such, the Convention on Biological Diversity, and here they're referring to, the access and benefit sharing arrangements under the Convention on Biological Diversity. And, in connection with the work that we do, and this would actually be more applicable in work in agricultural biotechnology. Certainly the principle of access and benefit sharing is something that we do take seriously and do take into consideration. But, well, I'm not going to say but we do take it seriously and into consideration. And in the sense that, again, we work with a wide variety of actors, including institutions in the developing world. And in that context, if we're working on developments related to, say, crop varieties like cassava or sorghum that are, or banana, that are crop varieties that are staples in the developing world, then it may very well be that some of those varieties originate locally, and we do engage in discussions with the institutions in the developing world where they originate and come from. And so it's factored into the discussion, I think probably in a more meaningful, in a meaningful and practical way, but without actually building into our agreement specific reference to the Convention on Biological Diversity.
Make resulting products affordable, available to the very poor.
So, right. So this is William New, IP Watch, wondering how the system, I guess the global access system, if you will, makes the products accessible to the very poor. Briefly and basically, as I said earlier, is that we do well, and this maybe going back to maybe not going back in the slides, but just imagining going back to that one slide where I laid out the range of activities that are undertaken in the development of a product from early stage discovery all the way through clinical trials and into the marketplace. One of the things that it's the sort of the timeline thing. Yeah, no. Well, anyway, certainly in very early stage discovery work, where it's just basic science, you don't know if you're going to be successful, let alone being able to take the science that you've developed and make it into a product. You can incorporate it into a drug or a vaccine or a new crop variety. So at that point, it's just not possible to establish terms and conditions around the manufacture of the product and about pricing concerns. And so as we go through the process, as I've laid it out, from early stage discovery all the way through manufacture and into the market, it's possible for us and our partners, our grantees, to become more specific about those issues. And so, the global access, and this was the point that I was making in the little parenthetical down at the bottom about it varies on the stage of development, is that as we get closer to the market, it's easier for us to understand the nature of the product and the utility it's actually going to have. We understand how that product is going to be used in the context of others that might already be in the market. We will understand better, what the demand is going to be, and the institutions that are going to be procuring and distributing it, what they might be looking at in terms of demand and volume. And then based upon that, we can have more detailed discussions about the specific point I think that William New was raising about price and its relation to access. So we do indeed have those discussions, and we have those discussions in connection with the projects that we fund. But the specificity that we can get to is obviously going to vary depending upon how close we are to the market. There's a question in the back. Yes, please. How it fits to what? Uh-huh. Mm-hmm. 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 Yes, it's a great series of questions, and I can, yeah. So to summarize, for people that are online, it's a woman. I should say that she's from an institution that works on veterinary vaccines, right? And is a grantee of the foundation. So a bit of a ringer here in the room. But her questions were, basically three. The first one referring back to, the chart where it indicated advocacy plans, and was wondering what the connection was between advocacy and global access and IP management. And that's really one of those where, and maybe I shouldn't have even put it in because there's a light connection at best. There may be some issues or questions that arise around IP that require some public discussion, but it's really not something that it needs to be contemplated or dealt with as a matter of course. And then the other sort of the more substantive question was, and it's a really, really good one, is in the case of veterinary medicine, vaccines in particular, there's some components or some aspects of the technology that are used for both veterinary applications as well as human applications. And then the question is, how you know, the IP rights are managed there. And then the third one related to that is whether at the foundation, you know, we have, you know, within the team within the foundation, you know, whether we provide some service, I guess is a way to put it, would be to, you know, to help to you know, facilitate these kinds of conversations and discussions. And on that last point, I would say that it happens in many instances, and I'm not as familiar, I must say, with veterinary vaccine, because that's more in the global development side of the house than global health, where I am. But I can tell you that in my experience is that what you've you know, described in terms of these kinds of cross-cutting issues that would apply to a number of grantees, you know, often arise as a matter of course, and you know, we do have those kinds of discussions. It's not sort of purposive and structured. You know, we don't kind of reach out and you know, try to sort of spontaneously identify those kinds of opportunities. And part of it, you know, kind of goes back to what I was mentioning before, is that we've established some larger collaborations, and you know, often in the context of those larger collaborations, you know, those kinds of cross-cutting issues are discussed. On the question of you know, the applicability of technology and therefore intellectual property issues around veterinary vaccine and human vaccine, you know, that is indeed, you know, something that we've seen, and you know, in the context of specific you know, funding arrangements that we've worked on in that context, you know, we have had discussions with the owners of the intellectual property about that, and I, you know, you may have had a different, you know, specific experience in your case, but in the instances that I've worked on that issue, it's been, in a sense, relatively easier to address that, you know, rather than, you know, these questions, these issues where you've got a you know, technology that may be applicable across geographic boundaries and may have, you know, commercial application in one geography and not so much in another, where the concerns are about parallel trade in the product and so forth. And in the instance that you're describing, you know, often it's resolved by, you know, working out appropriate field of use restrictions with respect to the license that could include with respect to the technical application, as well as, you know, the geographic, you know, use of the vaccine that arises for veterinary purposes. I don't know. I mean, I can tell by looking at you that you're not wholly satisfied with the answer, but it may be that maybe after this call or after this discussion, you know, we can get together, because it may be that you have a very specific point or thing that's that you're grappling with that I'm just not able to respond to right now. Go ahead.
Science very often is trial and error, very often more error than success. So you get lots of data and lots of information. But this is something negative in nature. Failed attempts, failed studies. And we know that it is very difficult often to get that information out, because a lot of interest in the person who made the test, but it can be of great interest to the wider scientific community. And I was just wondering whether your strategy and also possibly the role of in that field can be used to ensure access to data and information, not just to success stories, as important as that is, but also access to information and data about the failures, because they can be of great interest to the wider community, but often are not any longer of interest to the research who carried it out. Might not be detrimental to their interest, because one likes to be a failure.
Yeah, no. So it's a good question, and so the question is, I'll just summarize it. The question is, the approach that we take to data access broadly, and recognizing that not all of our projects are successful. Even though I was emphasizing success, they're not always successful, and that's absolutely true, even for the work that we fund. And so the question is, all well and good to ensure that the products that are successful get into the market, but what about failures and access to that data? And be very careful here that I want to talk not about the data access issues that are being debated in the larger world, but specifically with respect to our funded activities, is that we do have, as I indicated in the first prong of our global access, a goal to see to it that information, including data, is disseminated as rapidly and as broadly as possible. And in those projects that we fund where data is being generated, that's definitely something that we pursue. I can give you an example, and I keep going back to this because it's something that I know, but I also think it's a very good example. It's the collaboration for AIDS vaccine development, where in that context, we established with these 100-odd institutions a data material sharing agreement, that they have an obligation to share data, and we've categorized the different types of data that are generated in the context of that work. They share it amongst themselves, and then within a certain period of time, that data has to be disseminated to the wider scientific community, to get it out there. And necessarily that data, since not all of the projects are successful, that data will include those related to successful work and those related to instances where the scientific premise was disproved. So that's our goal, and that's what we aim at. We've had a pilot project that we've done in global health over the span of the last couple of years. That's trying to drive and establish more specificity with respect to the principles around data access, and requiring grantees, much like with the accelerated grant, above a certain level of funding, that they would be obliged to provide a data access plan. So explain how it is that the data that arises from their work is going to be made accessible. And we're moving more and more in that. Well, we have that as an objective of the foundation, that is access to data, and moving towards more specificity about what that means. Oh, great. So the question is, it's a provocative question. So the question is, whether in achieving global access we'd be better off without a patent regime at all. No. Why? I think I tried to, when I was talking earlier, I tried to talk about how we approach this issue in two different senses. One is the fact, and you're from a technology transfer office, and so you deal with intellectual property all of the time. And one of the senses is just that, is that we live and we work in a world where intellectual property systems do exist. There's international rules pertaining to intellectual property and at the local level. And I know that this is not a direct answer to your question, but I'm going to get to that. But we live in a world where intellectual property systems exist, and we work with institutions that deal with intellectual property rights all of the time. And so almost as a matter of course, when we make investments that are developing new technology, the question of intellectual property arises, and we address it. And then the other sense is, as I mentioned, and as you noted, I use the term leverage on a number of occasions. And we do see that there are certain areas of our work where we're making investments in technology that could indeed have application both within those markets that we are specifically charged to address and other commercial markets where the intellectual property could be used by the owner of it to be able to have some exclusivity with respect to products and make a profit, or license out the technology and generate revenue as a consequence. And given that we are in a world of intellectual property and there is that possibility, we do want to be in a position to be able to take advantage of it and be able to enjoy, if you will, the leverage that can bring. It's obviously, from the perspective of a charitable organization, it's a difficult line to identify and to be able to draw when it comes to the agreements. And often when I talk about these issues, I kind of refer to it as sort of almost a sense of rough justice, in the sense that yes, there is the system, and yes, it does enable the use of leverage to achieve some commercial advantage, but also yes, we need to ensure that our investments are leading to a charitable outcome. And whether it's the tax law that's requiring it, or whether it's driven by our overarching philosophy, we do want to see to it that the dollars that we spend go towards that charitable objective that we have in mind. But we can't be blind to what's what the larger world requires, and we need to take advantage of any tools that are available in order to enable us to achieve that charitable objective. So in a sense, it is a question of being mindful and thoughtful and good stewards of our resources, and use the tools that are available to us, including the intellectual property system, and doing it in a way, and this is really sort of both the art and the science of it, and doing it in such a way that we do have that right balance, and we do have that right singular focus on achieving the charitable objective, while being able to work with all of these other actors out there, including in the private sector, that have different goals and objectives and motivations and so on. And kind of circling back, and this is sort of a good segue, or a good way to circle back to the beginning when I was talking about these notions of creative capitalism. When I think of what, and I'm not going to speak for Bill Gates, I can't possibly speak for Bill Gates, but when he talked about this notion of creative capitalism and getting all these different institutions to work together, and I put that idea in the context of the intellectual property system, this is the way that it comes out for me. Is that we are working within a world where we have all these different legal arrangements and instruments, and we want to be able to take advantage of them in a way that enables us to work with all of these partners and take advantage of whatever tools and leverage and so forth that are available to us.
That's another question from Geneva. If there are any takeaways from what you said for the World Health Organization?
So the question is, are there takeaways for the World Health Organization based upon what I've said? Is that a question from the World Health Organization? Okay. Oh, from IP Watch. Yeah, but I'm not. I don't want to summarize what I've already said, or repeat what I've already said. But and I think what I've just said actually in summary towards the end of that last remark would be helpful would be perhaps something useful for the WHO. But I know that they're in the process of working on this paper between the World Trade Organization, the World Health Organization, the World Intellectual Property Organization, where as those institutions, they are working to identify, in this paper, what it is that, their, individual institutional mandates are, WHO with respect to health, WIPO with respect to intellectual property, WTO trade, or the TRIPS agreement. And, amongst themselves, I'm sure, working out some of these same kinds of balances and working towards justice and collaboration that I've described. So I really don't have anything, further beyond what I've already said that may be useful to the WHO. Yeah. No, no, it's a fair question, but as an institution, we basically leave those questions up to the member states of the WTO to resolve, or those that are responsible for that. We're I can tell you my personal views on a number of these things, but as an institution, we don't have a view on that. And the way that I look at it is that as an institution, the foundation, we're really heads down on these issues in terms of addressing all the stuff I've described in the context of the funded arrangements that we do. We certainly, again, we're cognizant of the fact that there are international arrangements around IP, that these are then embodied in national law. They result in individual instruments of intellectual property protection. And we take that result into account in the work that we do. And we've I think been very, very successful in terms of managing IP and managing license arrangements in the context of the work that we do. Given where we are at that end of the chain, from the international arrangements to the national to the local. And so as an institution, like I say, we're really heads down in terms of the work on the specific arrangements that we have in mind, rather than focusing on modifications to the global IP system. Yes.
I'm also one of the grantees of the Grand Challenge Inspiration Initiative.
Oh yeah.
And you can actually go on the website and it'll show you a list of all the projects. And then if you contact your project manager, they'll create a contact for you directly if you see something that's of interest. But also, I personally have a platform technology that can work with veterinary vaccines as well. So you guys can talk after that.
Well, let me just pause it there a second so I can say to the folks online that we have a gentleman who's also a grantee of the Gates Foundation, who was just responding to the other grantee in terms of veterinary and vaccines, he indicating that he has a platform technology that she may be interested in. So we're doing some science here as well as intellectual property.
Also, I have some very specific questions about the global access model, so I'm not sure. It's more in terms of I'm intending to collaborate with a company that already does provisional work for developing countries and offers their products at a lower cost. So I was wondering if that would satisfy the global access clause in and of itself, or if it would need to be something above and beyond that.
Yeah, I mean, the question is actually, it relates to global access plan or project in a specific grant. And maybe we can take this offline, but certainly, I mean, the question, if I understood it correctly, was that you already have certain agreements with respect to the provision of the product at low price in developing countries. And the question whether sort of the pre-existing agreements would be sufficient. and I don't know the specific answer to that, but certainly what you've described is an objective that we have. We are, as I indicated, keenly interested in price of products that arise from our funding in terms of getting into the market. And so I think that by all means that's in the right direction. But obviously I can't commit here. I mean, there has to be further discussion. And then of course there's the program officer that's involved in these discussions as well.
There's also just another brief one as well that I kind of introduced the WIPO research initiative.
Mm-hmm.
And I was wondering if that providing access to part of the IP in order for it to be used for neglected tropical diseases would satisfy the global access program.
So the question relates to WIPO research, which is WIPO is the World Intellectual Property Organization, and the WIPO Research Project is something that they've established in order basically to facilitate gaining access to technology, patented technologies, and know-how from companies that may be useful in research and development on neglected diseases. And I think, and I've had discussions with people at WIPO about that project, and it's very encouraging. I mean, certainly the motivation behind it in terms of making technology more readily available, identifying it both in terms of patent protection and know-how, making it more readily available for research projects for infectious diseases. That's a good thing. Whether well, and I guess the question is, whether entering into an arrangement in the context of WIPO research would be sufficient for global access purposes. Again, kind of going back to your earlier question, it's kind of hard to answer, that categorically. Like I said, it's definitely in the right direction, and I think that it certainly would be a good starting point, if not a good jumping off point for discussions about global access for a particular project that we're funding. But that again, it would require some further discussion on the specific project, and discussing it with the program officer as well at the foundation.
But I realize that there's a broad spectrum of opportunities out there. Most of them aren't commercial, so I would like to make it available anywhere as possible. So I was considering the WIPO research initiative as one of the ways to do that.
Yeah, and I think taking advantage of that is a good idea. But again, I don't know anything about your particular project and what the program officer might have in mind, and what would be required. But certainly, like I said, the WIPO research project is definitely in the right direction. And just maybe I can say parenthetically is that in my experience, and I've been working in issues in and around intellectual property and what we now call global access for well over a decade, 12 years longer, and going back to when I was at WIPO dealing with these issues in the late 90s. And since that time, there's been a lot of evolution, and there have been some new, very specific initiatives that have been stood up, like WIPO Research, for example, and some others. There also have been a large number of institutions, like product development partnerships in the field of neglected diseases, like tuberculosis and malaria and the like, that have undertaken to undertaken to do work in the way that I've described, where you very pragmatically, work in the management of intellectual property to be sure that their charitable objectives are met. So there's been progress, and not to say that either we at the foundation or these other institutions have all of the answers. I mean, as I've already indicated, we've got several pilot projects that pertain to questions that have been raised here that we're working on, and so we are ourselves, continuing to learn and evolve and develop. But it's certainly much easier to have conversations on these issues now than it was 10, 12 years ago, and there's just a lot more data and information out there in terms of how these kinds of things that are done that make that possible.
Thanks very, very much for staying so long. It's been a great pleasure. I thought the questions were really interesting. A big thanks also to the people online, and thank you for sharing your ideas with us.
Thanks for everyone online. Thank you very much. Thank you.